Hello and welcome to another episode of Investigators in Cars Drinking Coffee.
Good morning.
I'm your host, Mark Murnan, president of Complete Legal Investigations, and I'm here with my co-host once again with my beautiful and talented vice president.
Ooh.
Yeah, vice president.
I'm vice president today.
You are VP today.
I moved up.
You did. You're my boss. Wendy Strom Murnan, licensed private investigator, certified paralegal. And today, Wendy, we are talking about wrangling witnesses. I'm sorry, witness coordination.
Oh, yes.
Which we call witness wrangling.
Yes.
Wrangling, do you know what wrangling is?
Cattle.
It's a cowboy term.
Yes.
Yeah, you got to cut and get them.
Yeehaw.
Yeehaw. It's like herding cats, cat wrangling.
Yes.
But cattle wrangling, you got to get all those steers across to the, whatever the Wild West they did. You got to get them across the river, over to market.
Prod them, coax them, feed them.
In other words, we're talking about witnesses. And we've had a very intense week, just came out of a very serious criminal case with many witnesses, and this topic was fresh on our minds. So 3 keys to successfully coordinating your witnesses. 3 keys to coordinating your witnesses at a trial.
And getting them to show up.
So
yes.
The 3 keys are: number 1, rapport; number 2, patience; and number 3, firmness. So let's tackle them from the top. Number 1, when dealing with witnesses, you must have rapport. What's rapport?
Well, that's a relationship, and we're not just going to get on a phone we've mostly interviewed these witnesses already and tried to establish some rapport with them. Then we've just found you get a lot farther if you're nice to somebody, if you respect them, treat them with dignity. It's just called good old-fashioned people skills that investigators need. We're not police officers. We can't make people talk to us, as we've mentioned. So we have established this rapport. We're grateful to them. We thank them. We respect their time. So by the time we need them to show up in court, we've got this rapport with them.
Yeah, and during the initial contact, we always make sure we have their contact information. We'll have emails, we'll have cell phone numbers, work schedules, work employment information, so we're aware of that when we talk to the witness. But really, in essence, if witnesses knew what was involved when they spoke to us, they would never speak to us.
Yeah.
True?
It does, because it really happened in our case here. It led to them having to come down to court and testify in a very, very serious criminal matter, and they didn't want to do it, and they were sorry they talked to me. But luckily, I had enough of a rapport that they did come, and they did the right thing.
They did come, and when they got on the stand, they did the right thing.
Yes.
So that leads to number 2, and that's first is rapport. Second is patience.
Oh.
So
well, why don't you talk about patience, Mark?
Because I'm not qualified.
Is that your strong suit? No, you're very
patience. What's that?
That's why you need to talk about it.
Act as if.
Teach yourself.
Teach myself.
No.
Patience is dealing with all the problems that people have and that they bring with them to a trial.
Yes.
And we're not just talking about clients here. We're talking about witnesses.
Yes.
Witnesses' issues with their schedule. They have all of a sudden they have a surgery scheduled. All of a sudden something happens. We had a juror who had a situation with a spouse that was in an intensive care unit. All of these things can happen. A trial does not happen in a vacuum. It happens with real people dealing with real issues in real time, and they often spill over into a case, and requires the utmost patience on the part of the investigator who is coordinating these for the attorney.
Right, and everything zeroes in on one day. On this case, it was one day. I needed 20 witnesses. And I mean, it does not mean that was a good day for any of those people.
No.
So to just really be patient, again, establish that rapport with them, tell them it's inconvenient. You're sorry, you apologize, but they just, if they could just take a little time out, we would really appreciate it.
And they have to do that. We tell them, and then we'll get into number 3. But having patience with them allows us to empathize, but not sympathize.
Right.
We have to have empathy for the witnesses, but not necessarily sympathy, because let's face it, in a murder trial, someone's lost their life, and someone is looking at losing their life or their freedom for the rest of their life. So the stakes could not be higher.
Yes. Also, if they have a situation with their employers, we always furnish a letter. We tell them whatever you need.
Yeah.
We'll give you a letter, even though they have a subpoena. But then sometimes they feel better with an email or a letter for their boss.
Communication Act
that's
is
another
almost
way
like
we take care of them.
an
Yes.
intermediary between the attorneys and the witnesses.
Yes.
We're kind of like the middleman.
Yes.
But again, to the attorneys, I don't say this negatively, but the attorneys to the witness is a commodity.
Yeah, they've never met them.
They've never met them. They've never spoken with them. They've read our reports about the witnesses, but oftentimes the first time an attorney will meet a witness is at the trial.
Right.
And oftentimes not even until they call them to the stand.
True.
So
and they're relying on our reports.
Correct. They're relying on the investigator to maintain contact and to establish that rapport and to have the patience with the witness.
Yes.
All of which leads us to number 3, firmness.
Yes. And now that's what I'm so good at. Not.
So what do you do with a witness who tells you they're not coming?
Well, I had to learn, on this one especially, because it was so uncomfortable for most of them to come. A lot of them had fears. I had to learn to tell them, well, I have to tell you, you're under subpoena.
Yeah.
If you don't show up, you're in contempt of court. They can send the sheriff out for you. I just have to tell you that.
Yeah. And oftentimes I have to repeat that
Yes.
in slightly higher volume.
Then I have Mark call them.
But we did. We had a witness who simply refused to come, and the bottom line is, they either, and I've had to tell people this, look, you can drive yourself, or we can have a deputy bring you, but you must be in court.
Yeah.
Now that is a last resort, because if we've established rapport, number 1, if we have been patient with their circumstances, number 2, 90 times out of 100, 9 times out of 10, they will come.
Yes.
But there are situations when someone says they will come and they won't. We had individuals who, by all means, should have been there and simply did not show up.
Right.
And we have had situations. In one particular instance here, the law enforcement went to pick up a witness who did not want to come.
Yeah.
And brought that witness to court and had that witness testify. So that is
So
always
it does
an option.
happen if the attorney wants to enforce it.
And
one thing I just want to say though is don't ever threaten a witness.
No.
Don't ever tell them this is going to happen. You're going to really hurt the,
Yeah.
because that's tampering with a witness.
You cannot.
And you cannot cross that line.
You cannot cross the line. You have to know what the line is. As an experienced investigator, you should know what the line is, and you should be able to communicate. You should never cross that line with a witness. We tell witnesses all the time: don't try to help, don't try to hurt. Simply tell what you know.
Truth. Don't
tell
ever
the truth.
tell them what they should say.
Exactly. We need you to say this, or you need to say that. You can never do that. That is tampering.
Yeah.
But you can advise a witness who's been subpoenaed that they are under a court order.
Yes.
And that, if necessary, the judge could order a deputy, a law enforcement official, to go pick you up from your home if you're unwilling, or your place of employment if you're unwilling to come, or if you don't honor the court's order. That is not tampering. That is advising a witness of the consequences of not obeying a lawful court
You're
order.
obligated to tell them that.
you
Yeah.
do
One
have to
other
tell them
thing
that.
that I ran into here at this case, I interviewed people and had reports, and then when they came to court, they forgot what they told me conveniently, and they weren't going to remember. And I could remind them that they had told me something different a year before, but I could not force that witness to get on the stand and say it again.
No.
So that's when you have to back off, let go, and just let it take its course.
And let the attorney handle it.
Yeah.
Again, we are the running backs on the team. The attorneys are the quarterbacks. They're making the calls. They're the manager. They're
Thank
the coaches.
goodness.
They're the making the calls, and frankly, they have to sit with the client during a trial. And in criminal cases, they have to sit with the client while the client takes the heat.
Yeah.
So we are not in that position. We are there to support the litigation, support our attorney clients, and to do the best we can for them. But ultimately, the attorney has to make the call on whether to enforce a witness subpoena, whether to even call a witness. Oftentimes we've gone to great lengths to find what we think is a key witness, and the attorney, for for valid reasons, decides not to call that witness. And
Yeah.
Again, that's not our decision. Our job was to go find and get the information. The attorney has to make a decision whether that's appropriate or not. So.
Right.
But again, those are the three things in wrangling a witness, witness
Yes.
coordination, 3 keys to successfully coordinating your witnesses. Number 1, rapport. Number 2, patience. And number 3, firmness when necessary.
Yes.
So.
And then sitting in the hallway with them when they're waiting all day. And profusely apologizing and thanking them for their, being patient and, not yelling and, and then we even follow up with them after the trial and just thank them for everything they do.
We'll make a call, send an email, send a text message. Thank you for coming.
Yeah.
Your contribution was vital, no matter what the consequences of the trial were. Your contribution was important. It needed to happen, and you did that, and we are very grateful. So we communicate that.
Yes.
And again, I don't see that as the attorney's job. That's the investigator. That's our job.
We're the one with the relationship.
Correct. We've had the rapport.
Yeah. They came for us.
They came for us because they knew us. And they knew the client. Perhaps they knew the client, but they had something, and that oftentimes that is a relationship they had with the investigators.
Exactly.
So, anyway, well, that's 3 keys to coordinating a witness here. Want to remind you once again, if you have not subscribed, we are getting really excited about these. We're coming up with our second order on these because we're giving so many of them away. Our cool coasters. Hit the subscribe button, email us, or just
everybody needs a coaster.
Everybody needs a coaster here. So you get a coaster here. Don't spill anything on it. These are collector items. We appreciate those of you who have received them, who've posted them on social media. Thank you so much for that. And we will see you next time here on Investigators in Cars Drinking Coffee. Make it a great day.
Bye-bye now.